this is where things quietly turn terrifying. The state isn't just talking about punishment, they're talking about stacking time. That prior conviction is affirmed on appeal. This manslaughter charge can jump from a second-degree felony straight into first-degree territory. That's the difference between years, decades.
Mr. Coleman, yep. Good morning. You're Jacoby and Dorsey. And Mr. Dorsey, in cause number 25 DCCR 1896, you're charged with a second-degree felony offense of manslaughter from November 17th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in the institutional division of the Texas Department of Corrections.
Your Honor, it's my understanding he has a prior felony conviction that's enhanced to a first.
That is the way, well, it's not indicted that way, Judge, but I will be seeking a repeat offender. I'll be filing a repeat offender notice.
I wrote first degree on there,
Right.
and there's some confusion. He also explains that his underlying conviction is on appeal, I believe. That's what he tells me. So I told him I would check with the court to make sure that's right. If it's 5 to 99 or 2 to 20, because I didn't know the status of all the other stuff.
If it's on appeal, then potentially that could be an issue with regard to it being a final conviction. So what can happen is if that appeal, once it's complete, and if they affirm that verdict and that conviction, and at that point, this would then potentially become, for punishment purposes, enhanced to a first-degree felony if that conviction becomes final. And I don't really know, the final conviction date, if that creates an issue because of the appellate process.
I'm not sure, Judge. I'll have to look at it.
Judge, and I don't know the answer to that question.
Yeah.
But being familiar with this defendant, I tried him next door, involving several co-defendants. Ms. Duchamp and I did several years ago.
Okay.
He actually was on probation over there for cooperating with us for aggravated robbery involving an adjacent murder. He received 30 years on that revocation. I went back and double-checked, and I'm sorry to interject, double-checked that date. That hearing and that revocation was before this offense date. He had actually gone to Jefferson County Jail and was waiting on his 30-year sentence at TDC when this offense occurred in the jail.
And with that being said, Judge, the state will also be seeking, to the extent the law will allow us, to stack any sentence in this case on top of that 30-year sentence.
He's already filed the paper for that.
That 30-year sentence, though, is the one that was on appeal.
Possibly on appeal.
Okay. So I guess
So
that's
I
the
think our
question.
position would be that the decision that was made that was then subsequently
It would go back to the
affirmed would go
conviction
back to
date.
that date, yes.
That would tend to be what I would think, but we would obviously have to do a little bit of research to double check. And so I think that the most thorough way to do this is for you to understand that if that conviction is affirmed by the Court of Appeals, then it would appear that the conviction date then goes back to when that original conviction was, which was prior to the date of this offense. And therefore, it could enhance your punishment to that first-degree felony. If you go to a jury and they find that you're guilty and they find that conviction true, which means your minimum punishment would be 5 years instead of 2, up to 99 years or life in prison. Do you understand? In addition, if it's affirmed prior to any trial date or anything like that, and you're found guilty, Mr. Coleman can ask that any sentence that a jury gives you be stacked on top of or run consecutive to that 30-year sentence.
He's already filed that paperwork, Judge.
Okay, and that decision would be up to the court or up to me. So if you're found guilty, that could be a potential punishment in addition to yours, is that whatever the jury gives you, I could stack on top of that 30-year sentence. Do you understand all of that? I'm sorry, speak up. And I have a plea bargain rejection that you've signed here with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on just the count of manslaughter itself for a 20-year term in the institutional division. And that would be to run concurrently.
No.
That would be stacked.
That would be stacked, Judge. At least that's the offer as it stands. The state will entertain a counteroffer.
Well, I mean, that's, Okay.
I get it, Judge.
I can't, yeah, don't know why anybody would
No, I
accept
get
that offer. So, do y'all want to visit a little bit more about this?
I can
and
talk to him
before I
and see
put it
if-
on a trial
I
docket?
can talk to him about.
Let me hold it. Y'all visit a little bit about that before.
And then comes this moment, the plea offer. 20 years, stacked, not concurrent. Even the courtroom reacts. The judge openly questions why anyone would take that deal, which tells you just how extreme the stakes are right now. This isn't a resolution. It's the calm before a trial that could define the rest of his life.
Take this to the trial docket.